When you are representing bereaved families, I think your approach should at all times be informed by a number of important considerations. First of all, to remember at all times that although the bereaved family must be absolutely central to the inquest, they have not chosen to be there. In fact, finding themselves in this process is probably the last place they ever expected or wanted to be. They will probably have no previous experience of it, and every part of it will be alien to them. Your job is to prepare them for it. Secondly, due to their previous experiences, perhaps because of concerns that they already had about events leading up to the death, or because of what they believe to have been a flawed internal investigation, or just because of their own personal life experiences, they may be deeply skeptical about the conduct and motives of other interested persons, particularly state bodies, at the inquest. Thirdly, their loss and their grief makes them inherently vulnerable because they are bereaved. That vulnerability is quite distinct from anyone else's at an inquest, although other witnesses may of course be vulnerable too, for different reasons. And finally, grief, trauma, and loss can affect people in very different ways. In particular, memory can be affected. It can also mean that things that you might not think of initially as potentially re-traumatizing are deeply re-traumatizing for a bereaved family. With those observations in mind, the following may be helpful. While your role is to advise your client about what an inquest can and cannot achieve, and to manage their expectations appropriately, it will be a crucial part of your function to enable your client to express to you as much information as they wish to give about their and their loss. You will need to set aside as much time as is needed for that process. You will need to prepare your client as best as you possibly can for the extremely difficult process that lies ahead. In my experience, it is almost impossible to convey to a client in advance what it will actually be like dealing with the daily grind of trying to progress an inquest case, both in the months or sometimes years before the hearing, as well as during it, especially in a long and complex case. Legal arguments, disclosure delays, listing delays, problems with witness availability, what can often seem like cold or even hostile responses from other interested persons or even coroners can be extremely hard for bereaved families to bear, and it is your job to try and protect them and prepare them for that. You will need to encourage your client to come to their own view based upon the evidence that they will read and hear about their loved one's death. While your job is to try and secure the best outcome for the family, it can be very hard for bereaved families to accept the legal limitations of some inquests. Even in an Article 2 inquest, there may be limits to the evidence and the scope that the family may not think are fair. While advising as to whether those limitations are lawful and taking action where they are not, you will need to ensure that such limitations are explained carefully, more than once if necessary, as the case progresses.